Go.
Good afternoon. I'm Steve Spewak. I'm an estate planning attorney in the greater St. Louis area with Estate Plan Strategies, LLC, where for more than 25 years we've been giving our clients the peace of mind that what they accumulate in life won't be lost to the government, and the wishes they have for providing for their families when they're no longer here to do so will be fulfilled. Today I'd like to talk to you about 4 important legal documents that need to be amended in the event of your divorce in the St. Louis area. If you're in the process of a divorce or even getting ready to file, it's important that you talk with your attorney about the impact that that divorce will have upon your estate planning documents. It may surprise you to know, for example, that your ex-spouse may continue to have authority over your affairs and be a beneficiary of your estate. If you haven't changed who's your power of attorney and who the beneficiaries are on your accounts, that's exactly what will happen. If you have children, it's even more important to make sure these documents are amended promptly in order to avoid dollars going to a step-parent. If you die and your ex-spouse is the beneficiary of your estate, when your ex-spouse dies, it'll be left to his or her spouse, not to your children. These are examples of clear reasons to talk to a lawyer about the impact of a divorce as soon as possible after that divorce and make changes in your estate planning documents. There are 4 key documents to consider. First of all, there's your will. Fortunately, in Missouri, we have a statute which removes your spouse from consideration under your will in the event of a divorce. But it's still important to make changes to that document. If you and your ex-spouse are not on the same page as to who should be guardian for your minor children, you'll want to make sure that you update your guardianship provisions. And if you formerly had your ex-spouse in authoritarian figures like the executor of your estate, you'll want to substitute the appropriate people in those capacities. The second document that needs to be addressed promptly is your power of attorney. Your power of attorney gives the person that you've named in it the power to deal with your financial affairs if you're not capable of doing so. Most would shudder at the thought of their ex-spouse continuing to handle their bills and their finances. This document should be revoked immediately after a divorce and replaced with one that names the proper people. The third documents that need to be dealt with after a divorce are your health care directives. Your health care directives name the people who have authority to make medical decisions for you if you're ill and unable to do so yourself. Again, you would not want your ex-spouse to be in that capacity. The final and 4th set of documents to deal with immediately after a divorce are your beneficiary designations. If beneficiary designations are not changed on items such as life insurance policies, cash accounts, and investment accounts, and your ex-spouse continues to be the beneficiary on those accounts, that's who would get those monies in the event of your death, and it's easy to forget doing so. So as you can see, it's important to get your ducks in order after a divorce and talk to your estate planning lawyer about the amendments that need to be made to your legal documents in order to get everything in order. We're happy to help you start with the process. Please call us at area 314-542-2210 or visit us on the web at www.estateplanmo.com for more information about estate planning. The choice of a lawyer is an important decision and should not be based solely on advertisements.